contribution to this joint discussion on the right of housing will consist of 3 parts. The first segment will summarise the finding in the case of group boom. This segment will be followed by a discussion on how a case such as group boom might apply hypothetically to an Australian or specifically New South Wales context. Our video will conclude with a debate focusing on the value of such an approach from an Australian democratic perspective. So let's take a look at the facts of this case. The group boom case concerned a group of homeless people, including over 500 children, who had been evicted from land set aside for a low-cost housing project. Upon being evicted, the group applied to the local council for the provision of temporary accommodation. However, this request was not granted. The group then applied to the Cape High Court for an order requiring the relevant levels of government to comply with their obligations under sections 26 and 28 of the South African Constitution. Martina will now summarise this judgment as well as the subsequent appeal to the South African Constitutional Court.
Thanks, Ramona. In the trial case, the High Court found that the South African government had taken reasonable measures within available resources to achieve the progressive realisation of the right to have access to adequate housing, as required by section 26(2) of the Constitution. However, because the right of children to shelter in section 28 was not subject to available resources, the High Court held that Mrs. Grootboom and the community of squatters were entitled to be provided with basic shelter. Then an appeal to the Constitutional Court, the court found no violation of section 28, but instead found a violation of the right to adequate housing in section 26. The court held that section 26 obliges the state to devise and implement a coherent, coordinated housing program, and that in failing to do so, the government had failed to take reasonable measures to progressively realise the right to housing. The court ultimately ordered that the various governments devise, fund, implement and supervise measures to provide relief to those in desperate need. And now to the application in Australia.
In New South Wales, all residents are entitled to social housing if they can prove that they lack the means to meet their housing needs. In that same vein, those that find themselves in immediate need are entitled to private accommodation at the public expense. This is especially relevant for the victims of natural disasters, domestic violence, or those with dependents that rely on them. Policies attempt to provide support for those with special needs, including immigrants from non-English speaking backgrounds, disabled persons, and Indigenous people. As demonstrated in group room, however, there is often a deep disconnect between legislation and reality. While all residents are entitled to public housing if they lack it, waiting lists are short in rural areas but exceed more than 10 years in metropolitan Sydney. Funding shortfalls have allowed 150,000 public housing properties to fail even the most basic standards. 44% of housing need is simply not met due to underfunding and underinvestment into the public housing system. Beyond this, housing projects have increasingly tended to reinforce substance abuse and unemployment in those communities.
We're here at the Council Housing Estate in Waterloo, south of the city. In class, we discussed trends of social isolation in these public housing estates, which was exemplified by the lack of people in the parklands and playgrounds around these towers. In turn, this isolation raised difficulties in finding residents to interview. We did, however, have the privilege of interviewing one of the residents who declined to be filmed.
We have just spoken to a local resident who has been in the area for 7 years. He's declined to be on camera, but he gave us an insight into what it was like living in council housing in Sydney. He recounted that a few days ago a man jumped from the 7th floor and subsequently died, and additionally a couple of weeks ago there was a drug raid where $3 million in cash was taken, as well as 80 kilograms of ice. He said the conditions have improved significantly over the last number of years because of a high police presence and then focus from community-based organisations.
He had several concerns about the area with drug and alcohol issues. He said that in terms of waiting lists, people have been put in to housing here shortly after being out of jail or rehab. So that was some issues that he talked to us about.
We also discussed the contrast between these terraces in Woolloomooloo and the high-rise towers a few suburbs away in Waterloo. Population density and town planning constraints reinforce the overcrowding that can facilitate social problems, such as crime. Aware of the potentially confronting nature of public housing resident interviews, we engaged another local resident in Woolloomooloo who did not live in public housing.
As someone who lives close to a lot of homeless people and public housing, what, in your opinion, do you think needs to be improved to help such vulnerable people?
I think there's definitely a mismanagement of funds that's being used. They tend to put in these really nice areas such as parks and sort of community areas, but then they let them get run down. And when they get run down, then you have sort of alcohol and drugs and stuff. But I think just more connection with what's actually going on. I think it's one of those things that they're just throwing money at and going, oh, that'll solve the problem. When in fact, I think it needs, that money needs to sort of be better managed.
Access to support services was also discussed as a criterion for reasonable housing policy. We interviewed a fitness trainer at the Police Citizens Youth Club, or the PCYC, in Woolloomooloo, which provides gym and other facilities to youth in the area to, quote, get them off the streets. Do you think public housing has improved in the past 15 years?
From my own personal experience, I think slightly improved. But yeah, you can always improve.
What would a group boom style ruling look like in New South Wales? So the South African example is difficult to translate into New South Wales, where the debate concerns adequate standards rather than basic shelter. Reasonableness, however, is a test that must be applied with reference to the context, including the higher capacity of the New South Wales government to deliver services to its citizens. A court applying the group boom style reasonableness principle could possibly respond to these issues in the following ways. It could order the government to develop a long-term plan to reduce waiting lists in urban areas, taking into consideration the availability of properties in rural and regional areas. Secondly, develop long-term plans to improve conditions in the existing housing stock. And it can finally develop a plan that bridges the gap between emergency and public housing.
And now to the pros and cons of this approach.
We are in favour of judicial review of rights, such as the right to access public housing in an Australian context. Courts are an independent body that can regulate government policies and are able to deal with injustices and issues that the government may overlook. Courts, as opposed to other internal government review mechanisms, are more effective in bringing public attention to sidelined issues. For example, prior to the discussion that we had today, a few of us were unaware of the particulars such as waiting lists in order to access public housing, but a court case would be able to bring public attention and draw public attention to those particulars and those issues. Judicial review provides another forum for public debate.
Secondly, courts are most effective at protecting minorities because they are separate from the parliament and are therefore less susceptible to populist views in which minorities are often overlooked. Therefore, it espouses a broader conception of democracy in which the minimum rights of the most vulnerable are protected.
In relation to the right to access housing, it is preferable for the judiciary to review such policies because the homeless and vulnerable minorities, such as sufferers of domestic violence, disabled people, and also those with mental illness, are often severely disenfranchised. The court is able to assess reasonableness and to take into account general notions of human dignity in an impartial way.
A third reason that judicial review of economic and social rights would be desirable is that it holds governments accountable for their policies. By passing a statutory charter of rights, the government has laid out a series of rights and aspirations which it has promised to uphold. Moreover, on the international stage, it is publicly committed to these rights and aspirations by signing up to international human rights treaties. So it only makes sense that a court should be able to call out the government when its policies are clearly unreasonable relative to these values it maintains. If a court were able to review government policy for unreasonableness, then governments would have an added incentive to respect and promote these human rights so that they can avoid litigation, controversy, and public embarrassment.
The right to housing is interdependent with and indivisible from other rights. Courts should pay attention to whether the state is upholding socioeconomic rights holistically. At paragraph 23 in the Hutbun case, the judgment speaks of interrelatedness and mutually supporting nature of the South African constitutionally entrenched rights, both civil, political, social, and economic. Judicial review of rights understandably highlights the reality that freedom, human dignity, and equality are denied to those who don't have food, clothing, or shelter. It's only when these rights are realized that rights such as race and gender equality can be pursued, and people can move towards realizing their full human potential. And for these 4 reasons, we favour judicial review.
We will endeavour to outline some reasons why the judiciary should not assess the reasonableness of housing policy. There's a democratic cost to having judicial review of socio-economic rights. This cost has 2 dimensions. Firstly, this may undermine public confidence in the perceived independence of the judiciary who are making value judgments on the reasonableness of government policy. We acknowledge that this kind of judgment is implicit in other areas, but it is more acute and overt in this area. Secondly, such a move would load the dice in favour of the judiciary's vision of appropriate housing policy. For example, if the court were to determine that a 10-year waiting period was unreasonable, that doesn't leave the government complete scope to redevelop the policy for the short to medium term. This itself has an associated democratic deficit.
Further, judges lack the economic expertise to make or interpret complex policy arguments regarding housing. Policy matters concerning housing involve a complex matrix of budgetary concerns. While ministers may not have the relevant expertise, they are often advised by economic advisors, whereas courts are not.
If judicial review is weakened in the style of Groupon to accommodate democratic concerns, it will fail to be effective without significant further resources to follow it up. Much like the aftermath of Groupon itself, there is unlikely to be a major impact securing the achievement of housing rights. Litigation itself would be expensive, and so would this kind of follow-up. We think there are better methods of promoting democracy and accountability that are more cost-effective, such as through the role of parliamentary scrutiny committees, the Auditor General, and a healthy system of political party competition. The existence of healthy political party competition might be a reason to distinguish Groupon and South Africa compared to Australia and the United Kingdom.
On the other hand, if judicial review is strengthened to ensure its effectiveness, this means judges will be playing with billions of dollars, and once again we have serious democratic and confidence-based concerns. So those are our 4 objections to judicial review of socio-economic rights. We look forward to hearing your thoughts. Over to you.
Thanks for watching. We hope you enjoyed the video and we look forward to your response.